Let's turn to more breaking news just in from Washington. We just got a major decision from the Supreme Court on redistricting. Let's go to Lisa Rubin, MS Now senior legal reporter. Lisa, bring us up to speed.
Well, Anna, this decision is one of the most eagerly anticipated of this Supreme Court term. This is a decision coming out of Louisiana, which the court was deciding whether or not the creation of a second majority-minority voting district for its congressional races was constitutional or not, and whether or not it was in compliance with the Voting Rights Act. Here, the court is deciding by a 6-3 vote and a decision authored by Justice Alito that the map that Louisiana created in order to comply with the Voting Rights Act is not a map that can stand. The court's saying that the Voting Rights Act sometimes justifies racially based decision-making consistent with the Constitution, but here that while the state's efforts to comply were laudatory, this particular district is a racial gerrymander that cannot stand. That means that it will go back down to the lower courts for further decision-making about the composition of congressional maps in Louisiana. But this could have reverberations beyond Louisiana as well, Anna.
And I want to bring in Leah Lippman, who's standing by with us. Leah, give me your reaction to this ruling. Okay, we'll come back to Leah as soon as we have some of those audio and technical issues figured out. Lisa, as far as the implications go on this, the Voting Rights Act we know is important here, and the population in Louisiana is about a third Black. So will their voices and their votes be heard? I think that's the big question people are asking, given the map was drawn in response to a previous ruling that they needed to have more representation, this population.
Yes, and what the court is holding here, Anna, is that this was an unconstitutional racial gerrymander. So you have to ask, are the lines going to be drawn in a way that disperses the votes of African Americans in the state of Louisiana such that their voices will not be heard in the way that we have traditionally understood the Voting Rights Act to support? That's a legitimate question on the table now, how the state is going to redraw these maps in a way that both complies with the Voting Rights Act, but also comports with this court's decision today, an unambiguous decision where you have all 6 of the court's conservatives in the majority, and you have 3 of the court's liberals in dissent. I have yet to read the dissent. We've got 92 pages of decisions here, but this is one that we expected could have large reverberations across the country. And I just want to situate this in the context of some of these larger redistricting fights that are happening across the country. We are seeing a number of states try to redistrict for political reasons, to gain a political advantage. And while we see whether or not, for example, the Virginia maps are going to hold or whether Florida is going to redistrict, this adds a whole new variable into those House maps for the 2026 election. Are states going to now reconsider some of their maps in light of today's decision in ways that could even further throw the balance of power of the House of Representatives into disarray?
Lisa, stay with us. I want to bring in Barbara McQuade. She's former U.S. attorney, also an MS Now legal analyst. Barbara, what's your reaction to this decision?
Yeah, you know, on its face, it looks a little less than I think many people had feared, because there was some concern that the majority of the court would strike down the Voting Rights Act in its entirety. Justice Alito, writing for the majority, does say that voting rights based on race is a compelling governmental interest, and as long as maps meet strict scrutiny, then those are permissible. But then they turn around and say, but this one doesn't, and that racial minorities are entitled to electing the candidates of their choice. But that doesn't mean based on race. It just means they can choose the Republican or choose the Democrat. And because these voters can do that, then there is no need for this second district that was created to provide a majority Black district. And so that might sound okay on a first blush, but I think the real disclosure of what's happening here comes in the dissent of Elena Kagan, who says that today's decision renders Section 2 of the Voting Rights Act all but a dead letter. She talks about how the Voting Rights Act was born of the literal blood of Union soldiers and civil rights marchers. And this betrays a faithful implementation of the Equal Protection Clause. So on its face, it looks sort of innocuous. She says even antiseptic. But in practice, I think this is going to mean that it's going to be impossible for minority voters to ever make out a claim under the Voting Rights Act, Section 2.
Right. And as I mentioned, I want to bring in Leah Lippman for this. The current maps that are now being thrown out were drawn after courts had ruled that the previous map didn't adequately represent the population there and was in violation of the Voting Rights Act. So what is the Supreme Court suggesting is the proper remedy? Leah,
Sorry,
can you hear me?
For Leah? Is that for me or for Leah?
So it's for Leah.
What the Supreme Court is saying is that the Voting Rights Act actually did not require the state of Louisiana to draw an additional majority-minority district. So instead of striking down what remains of the Voting Rights Act, Section 2, and its protections for multiracial democracy and districting, the Supreme Court has adopted an exceptionally narrow and cramped reading of Section 2, one that will essentially almost never require states to draw additional majority-minority districts. What the court effectively said is, so long as the plaintiffs who are challenging these maps that states draw can't identify an alternative map that would both provide an additional majority-minority district and retain the same partisan composition as the state's initial map, then the state often isn't going to be required to draw that second district. The reality, however, is that there's racial polarization in voting. So race and party are inextricably linked. And what that means is it's almost never going to be possible for plaintiffs to show that a state can draw an additional majority-minority district, but that additional majority-minority district will still vote Republican in the way that the previous district would have. That's why Justice Kagan, in dissent, is writing for the Democratic appointees and calls this ruling one that renders what remains of the Voting Rights Act a nullity. She situates this latest ruling in a trilogy of cases that the Supreme Court has issued dismantling the Voting Rights Act. She says, look, back in 2013 in Shelby County versus Holder, the court effectively nullified what was the preclearance regime, which required certain states with especially egregious histories of voting discrimination to get the federal government's permission before changing their voting laws or policies. Then in a later decision, Brnovich versus DNC, the Supreme Court effectively made it almost impossible to challenge what are called voting preconditions, rules that affect who can vote, like a voter identification requirement. And since that decision in Brnovich, there have been zero successful Section 2 challenges to voting conditions. The decision today in Louisiana versus Calais completes the set, because it effectively dismantles the last leg in the Voting Rights Act's protections, which was for redistricting. Whereas previously, the Voting Rights Act had said when a state draws districts in ways that have the effect of diluting the voting power of racial minorities, of effectively making it so racial minorities' votes count for less than white voters and that they can never elect the candidates of their choice. Now, the Supreme Court has said, go ahead, state legislatures, draw districts, maybe even redraw districts in ways that lock voters of color out of power. That is to undo the Voting Rights Act and what it did for this country, namely make it into a multiracial democracy.
Lisa, what happens now with the midterms? Does Louisiana have to create new maps?
It does. Anna, the very end of the decision says that this is going to be remanded to the district court. And by that, I take it to be a 3-judge panel in the Western District of Louisiana for further proceedings, which means that Louisiana's maps will be withdrawn. Unless Leah understands that differently, that's my understanding of today's decision. The other question, though, of course, is whether or not other states will also use today's decision as a basis to further redraw maps in their own states. It used to be that decade, redistricting was an anomaly, something that we never saw unless called for by a court's decision. But of course, we are now seeing across the country all sorts of reasons for redistricting. And this Calais decision may be a pretext for other states to say, oh, wait a second, we have too many majority-minority districts that wouldn't pass muster under the new configured test for Section 2. Given how stringently the court is drawing that test, maybe we too need to configure our own districts before they're challenged in court. So I do think Louisiana's maps will be withdrawn at a minimum, and we may see some other states try to do the same in theoretical compliance with today's decision, Anna.